In this segment, we're going to talk about external relationships. Obviously, any business is going to need to interact with other people, be they suppliers or customers or both. And with each of these relationships comes a risk, because at the end of the day, there's a need to manage self-interest. Even if you're dealing with an advisor or someone who's offering to assist you, they want you to make money from the service they're providing, and you cannot assume that they're going to do the right thing. So, like all relationships, we saw it in the earlier section dealing with shareholders, you need an agreement that just sets out the basis on which you're going to deal with that person, and that's the best way of managing the risk. Again, at the start, when the relationship is fresh, optimism is at its highest, and where people have not formed an adverse view. So I'm going to go through a number of relationships and just point out some of the things that you need to take particular account of when dealing with those relationships. And let's start with employees, because that's probably where most people will start. And when I say employee, I'm talking about people who are employed, for whose wages you're deducting tax, for whom you may be paying superannuation. We'll deal with contractors separately. So with employees, there is a lot, and I repeat, a lot of law that deals with an employer's ability to hire and fire, to caution, to deal with their staff. You can obviously employ people without a contract, and you can fall back on that law. And the law does work both ways, so there is certainly an implied duty on the part of an employee to keep the affairs of their employer confidential. But again, it is much easier when something goes wrong to be able to bring out a piece of paper, the contract, where the employee has agreed to keep things confidential, where they have agreed that any intellectual property rights in the things that they have created belong to you. That does regulate the amount of notice that you have to give them. But just bear in mind that the contract is about 90% of it, and you always need to be thinking about what the legislation says and what Fair Work Australia might say in terms of you needing to counsel, and particularly when you need to come to fire people. But at the end of the day, there is nothing to stop you hiring and firing. When you choose to do so, you just need to make sure that you've done it in the proper way, so that it is always useful when your business gets going and where employees are not bound by a personal relationship with you, that you are getting some advice before you start implementing any process to get or terminate someone's employment. And as the business evolves, you will find a need to have more and more policies, things that may be obvious to you, but may not be obvious to employees. And there are a number of online services where this advice and assistance can be obtained cost effectively. At the start, you're probably going to be making greater use of contractors. Now, this is helpful in the sense that a contractor isn't subject to the Fair Work legislation, and is like any other commercial relationship. If the contract says it can be terminated on 1 day's notice, it can be terminated on 1 day's notice. The danger with contractors, and we see this a lot, particularly when we come to an exit, is that people are employed or engaged as contractors, and it may be because that's the way they want to be engaged. They think it gives them some tax advantage. But really, when you analyse the relationship between the company and the worker, it is one of employer and employee. And the problem is that if someone is engaged by you as a contractor and they're not really a contractor, and you don't deduct tax, and you don't pay superannuation, and you don't pay workers' compensation, then there may come a point in time when you have to make good those payments, even though the amount you've paid to the contractor was based on the fact that you weren't paying those amounts. And this is a big issue for the government, because a lot of workers are falling through the cracks and aren't providing for what happens if they're injured, and aren't providing for their retirement. So by all means, use contractors, but if you're finding that in 2 or 3 years' time, the majority of your workforce are on a contract basis and are working for you full-time, I suspect you will find that if you did an analysis, those workers will be employees. So just be alert to that, because it can be costly to fix up. Now, within the Catalysr environment and in other environments, other incubators or accelerators that you may participate in, you will meet people like me providing legal services. You might meet accountants who are providing accounting services, and you're going to find any number of people offering their services as mentors or advisors, either generally or in a specific area. All of these relationships need an agreement as well. Lawyers actually need to do it because we're told to do it under the legislation that governs us. But even for mentors and advisors, you need to have an agreement, and the agreement needs to cover off the things that you're expecting the advisor to provide and what you're going to give them in return. Is it cash? Is it some shares? And you set the expectation at the front, because we often see people who've met an advisor, there's been a rush of blood to the head, the advisor's been advising, there's been no agreement, and then all of a sudden the advice has turned out not to be quite as good or relevant as was expected, or some other issue arises, they're maybe too busy to give you the attention you want, and so the question then is, how can that arrangement be brought to an end? And without an agreement, it gets messy, and even advisors can make suggestions for your business that may result in some intellectual property being developed. You want to make sure that you own everything that you're developing. So again, even though it may be slightly uncomfortable with a mentor or advisor, make sure you get those things documented. Now, obviously, when you're dealing with suppliers and customers, it gets even more critical because these are people who you will have an even remoter relationship with. You may only have an interaction with them every so often. So let's look at suppliers first. If you're taking on board materials or goods or services, you need to know the basis on which those services or goods are being provided to you, and what rights you have if they're no good. And again, if someone's providing services externally, what happens to any intellectual property rights? So again, none of these things are standard and need to be tailored for the particular requirements. Clearly, if you're buying stationery from Officeworks, their proposals or quotes will come with some standard terms and conditions. That's not a problem, but when you're dealing with more bespoke services, be it like product design or engineering services or the building of a mould, you need to understand what the arrangements are. Do you get to own the goods before you've paid them, or do you only get to keep the goods and own them once you have paid for them? What does that mean if there's then a dispute about the amount due? So again, it's always good in the early days to get some advice so you know the key things to look for. There's often only half a dozen clauses that become subject to negotiation, and once you've had some experience, you'll be adept at doing these things yourself. With customers, a bit depends on whether you're selling a bespoke solution, and any sale is preceded by a lengthy negotiation. Clearly, if you're supplying high-end equipment to a large company, that will occur. I suspect a lot of people in this cohort will be having a business where you're dealing on a more business-to-consumer level, or if it is business-to-business that is more SME-style business, where you won't have as much interaction, and indeed where you want people to sign up to some terms and conditions on your website. Again, there's a lot of material out there, but time and time again people come to us with a business and you have a look at the terms and conditions, and they've copied something from the US where the law's quite different and where the consequences, if not spelt out in the contract, will be quite different. So again, no such thing as a standard contract. By all means, cut and paste and borrow to get started, but as soon as you've validated your business and getting custom, then you need to have a look at those those to make sure they are suitable for your business and, more importantly, reflect the way you want to do business. I know many people may not read those terms and conditions, but some people do, and certainly when a dispute arises, a lot of people will be looking at the words and trying to figure out how those words regulate what has gone wrong. The final thing around agreements is that as you try and get your business advanced, you will be thinking, can I engage a distributor or a reseller, someone who will help extend the reach of my offering to more people? And these people typically will take a percentage or a commission of the revenue that they bring in for you, or maybe profit. Again, there's lots of ways these deals can be constructed. These are important agreements because you're probably going to be relying on them to deliver the results that you say you will deliver when you've presented to your investor. And so you need a contract that will hold your distributors, your resellers to account if they're not performing, will allow you to have a conversation with them, at least maybe to encourage them to work a bit harder, and if the worst comes to the worst, to be able to allow you to say the relationship isn't working and can be terminated or maybe reconfigured in a different way. So again, all of this is about having an independent record of what the arrangement was. This really has two main benefits. Firstly, if something does go wrong, everyone can remember what was agreed, and oftentimes in a large company, the person that might have been the account manager 12 months ago is no longer the account manager, so someone else is now managing it. So again, having the record of what we agreed is important. And often that resolves the matter. People will look at it and remember and say, yep, you were right, and that's the end of the issue. But if there's still a disagreement, a contention, then if you have to go to a judge in the worst case, or you're trying to find an informal way of resolving the matter between the lawyers, then looking at this agreement, oftentimes the agreement will provide the answer and will enable the parties to come to a much quicker solution. Without the agreement, a lot of time is spent and probably wasted by trying to analyse what the agreement was.